Welcome to Requiro. Today we are going to be talking about... Hi, it's voice over me. So I made a massive mistake. I thought this document was a document written by Karen Agnifilo, but in reality, no, that's not what this document is. I realized this document is a document by Judge Garnett that came out on the 30th of January 2026 of denying the motion by Karen Agnifilo to suppress everything in Luigi Mangione's backpack and also some of his statements. This is what this document is. So I do apologize. I'm gonna keep the rest of the video in because everything else I say in the video is relevant to what's going on, but I just thought I need to put this here. So yeah, sorry about that massive mistake here. And the moral of the story is I don't know, I'm human and I make mistakes. This document came out on the 30th of January 2026. That came out on the same day as Mark Agnifilo's filing that came out on the same day, and also Karen Agnifilo's Memorandum of law that also came out on the same day. I've made videos of those two documents. Again, I covered them in my last updated video in Luigi Mangione's case. They were just way too big to cover in that one video because they are a good couple of pages long. So this video is just basically a audio version of this full document, like I've been doing for the last couple of weeks, just making audio versions of these ginormous documents just so you guys can go listen along to them. Firstly, sorry if my camera goes in and out of focus. I don't know why it's doing that today for some reason, even if I film at the same type of distance that I normally do, so hopefully it's not out of focus. And I also want to say sorry about if you hear any dog snoring in the background, just because this microphone's way better quality now. It picks up on so many more sounds because there is a giant cloud right next to me sleeping. I'll show you a picture in a minute. I'll put her up on screen. She's very cute. No, please don't knock off my things. She is such a big dog. Okay, you can see her. Anyway, so this document came out like the other documents, like I mentioned before, but this document was going over and arguing to suppress all the alleged evidence that was found in Luigi Mangione's backpack, at the McDonald's, at the police station, and also the statements Luigi Mangione made to the Altoona police. But like we already know, because it came out months ago, sadly Judge Garnett did not suppress any of the evidence in this case when she made her decision. So basically that's what this document is, and this is just a audio version of this document. I know it's many months late, but again, I am one person working on all these videos. I need to do things in my life that take me a little bit of time to do these. So again, apologies, but you guys don't mind. So here is a couple of things I want to bring up in the video before we get into the main part of the video, the audio version of this document. So basically on the 18th of May 2026, Luigi Mangione appeared in court again. Now, this was the result of when Luigi Mangione had his massive December suppression hearing that lasted about 3 weeks in December last year. Like we already know, I covered the live tweets from the December suppression hearing. We still haven't got transcripts for that time frame yet. I don't think we ever will. I still don't believe the Reddit transcripts from Reddit. So recommend, if you guys want to know what happened in the December suppression hearing, there was a document written by Karen Agnifilo that goes over all the key points that I broke down in my massive videos going over the live tweets and stuff. There is a document written by Karen. I forgot the name of it right now, but I will put that in the description down below so you guys can go, listen or read to it. I also made a video about that as a audio version if you guys want to know what happened. Basically, this hearing was the result of that 3-week long December suppression hearing with Judge Caro. Now, I did make a little video about it the other day when it happened, on the 19th of May 2026, because I live in Australia. I get news in this case one day after it actually happened. Living in the future, guys. But I do want to bring up some things here, and there are photos that came out on this day, so I will describe Luigi Mangione's appearance a little bit and my little bit opinion about it. He was granted to wear court approval clothing, but Luigi Mangione was still handcuffed and shackled. You can see in the photos here as well, and he was wearing socks when his ankles were handcuffed this time, compared to what we saw in the past where they did not do that whatsoever. It's also good as well, but it is sad to see Luigi Mangione was still handcuffed and shackled, and his handcuffs were attached to the little belt thing. You can't really see it that well, it is covered by the suit he is wearing, but I couldn't really see his wrists to see if they had the handcuffs too tight on his wrists, where you could obviously see bruises. Again, I bring that every time I see it. I couldn't really see it this time, but I'm not doubting if the bruises weren't there, so I'm pretty sure they were there, because and I brought this up multiple times in the past, they very much do play this kind of stuff up when there are cameras involved, where they like to shackle and humiliate Luigi Mangione. We've seen it many times in the past, like last year, multiple times when he was first arrested. Months after that, in every other hearing where there were cameras involved, they did very much keep him shackled, parade him down the hallway, do that stage per block, etc. We've seen it multiple times. They do play this kind of stuff up when the cameras are around. But I kept having this thought every time I saw the photos of Luigi Mangione on this day, and also when I was watching the footage as well of this hearing, Luigi Mangione just looked incredibly stressed in this entire thing, and I could not shake that every time I saw it. And also, I'm not sure if it's just a me thing, every time I also saw the photos, I kind of thought he did lose a little bit of weight compared to the photos we've seen in December last year. It's been about 6 months since then, but I don't want to make opinions about people's bodies, because people need to keep that shit to themselves unless it's getting dangerous for them, then get them help. It's coming from a place of concern, he kind of looks a little bit of when he was first arrested, not as bad, and I think he might be just be incredibly stressed. I think it just might be just me. He probably looks exactly the same like he did in December last year, and I'm just see something else, and it's just me with the camera angles, but I'm just a little bit concerned. This was actually recorded, and I will put that in the description down below if you guys want to go watch it. I'm putting the actual full 30-so-minute video. Majority of it is just silence with Luigi Mangione's face, just him moving around and stuff, compared to the 15-minute one that has been floating around. I think they just cut out that big section when no one was talking, but I want to give you guys all the accurate and correct information, so I'll put the full video version in the description down below. But I will cover all this in a lot more detail, going over updates in Luigi Mangione's case. This is me just going over it quite briefly and give you guys a quick update. I did make a little video about it as well on my social medias if you want to go watch that. Again, I don't post shorts on this channel anymore, just because you already know, my original channel got taken down by YouTube, and I worked out the shorts. They prioritize to take things down a lot quicker compared to, say, my longer form videos. Basically, on this day, some things were suppressed and then other things were not suppressed by Judge Garnett, and I found that kind of interesting and also a little bit odd at the same time. Why was it 50-50? And then also some things were suppressed, but then there were things that weren't suppressed, but they were also found at the McDonald's. Why was that not suppressed? Again, it's a little bit odd, but again, I do feel like this was the best case scenario for Luigi Mangione and his legal team. We already know, even if we all would have wished everything was suppressed in Luigi Mangione's backpack, I was a little bit worried because it is Judge Garnett. He is incredibly biased towards Luigi Mangione and his legal team. He wasn't going to suppress things in Luigi Mangione's backpack and statements he made. Some things were suppressed and then some things weren't suppressed in Luigi Mangione's backpack, so I'll go over them quickly here. Again, this is just brief. I will go over this in more detail in my updated video in Luigi Mangione's case. And if there's anything I missed, please let me know in the comments down below. Again, I am human, I do make mistakes, and I do miss things. So the things that were suppressed in Luigi Mangione's backpack by Judge Garnett was everything that was found at the McDonald's was suppressed, and the things that weren't suppressed were the things that were found at the police station. I do find that incredibly odd. Like, there was so many incredibly suspicious shit surrounding the backpack when it was going to the police station. But again, I'll go over this in more detail when I make my updated video, and I'll be very more angry then. So these were the things that were suppressed in Luigi Mangione's backpack that were found at the McDonald's. So Luigi Mangione's wallet was suppressed, Luigi Mangione's passport was suppressed, and Luigi Mangione's phone was suppressed, and also the computer chip that was found that Officer Fox spent way too much time opening at the McDonald's when they were claiming they were looking for a bomb. You know, time was on the matter, but you guys were spending way too much time opening a little thing. Anyway, a gun magazine that they were so excited about that they found in Luigi Mangione's backpack was suppressed in Luigi Mangione's backpack, and also some of the statements Luigi Mangione made at that McDonald's were suppressed as well. And the things that weren't suppressed in Luigi Mangione's backpack, like I said earlier, was the things that was found at the police station in Altoona. Again, find it incredibly odd when so many incredibly suspicious shit was surrounding the backpack before it got to that police station. Anyway, things that weren't suppressed in Luigi Mangione's backpack was 3D printed alleged gun, 3D printed alleged silencer, and also the red notebook they found in Luigi Mangione's backpack, and also a USB drive found on Luigi Mangione, and also some statements Luigi Mangione made was not suppressed. Now, I do want to say it was a bit odd for them to keep the red notebook when that was also found at the McDonald's. Again, where that notebook was found at the McDonald's, it came out in many documents where it was placed on the table at the McDonald's, but then that's also kept, and it was claimed it was found at the police station. Again, I think I was in a little bit of a grey area, but I will go over this in a lot more detail in my updated video in Luigi Mangione's case. Sorry, I'm repeating that multiple times. Now, I do feel like this is the best outcome for Luigi Mangione and his legal team compared to having none of it be suppressed, like what Judge Garnett's decision was. And I was honestly surprised because, you know, Judge Garnett is incredibly biased towards Luigi Mangione and his legal team, so it's nice to hear a little bit he was being a little bit more fair in this, having some things suppressed and some things weren't suppressed. But I did find that a little bit odd when I first read it at, midnight when it came out. I did read a little bit and then I fell asleep because I didn't want to know the answer. I wanted to be distraught if the answer was bad in the morning, not at midnight. But I do feel like this is the best result for Luigi Mangione and his legal team. I think they were also expecting it as well. Said about 500 times already. I will cover this in a lot more detail in my updates in Luigi Mangione's case. I just want to put it here because, again, it was a big thing that has happened. And another thing I really want to add here is this was another really big thing. Now, like you guys already know, I don't really talk about the gossip side of things or the drama surrounding the Luigi Mangione fandom community-ness. I don't really know what it's called, I just call it whatever. But this was also a really big thing, and I do feel like it's necessary to talk about it because, like I've said before in the past, if it does start to affect Luigi Mangione's case, I will step in and talk about it. And also, I think this was big enough to talk about just because of how fucking disgusting it was, and it was big enough for Karen Agnifilo to talk about briefly to a newspaper, and also the new mayor of New York, Zohran Mamdani. Please tell me I've pronounced his first name correctly. I've watched the actual video of how he says his name.
Zohran Mamdani.
You're allowed to yell at me if I got it wrong. Mr. Mamdani, the mayor of New York, to speak about this issue, and also Karen Agnifilo, Luigi Mangione's lawyer. And I think it's necessary to talk about this as a person who is in the Luigi Mangione supporting community. You can clearly tell, and also for every other person who is in the Luigi Mangione supporting community. Normally with this, I would not give these people show their pictures or anything like that, because I don't want to give them what they want, is more attention, but I will show you the newspaper clipping so you guys know what their faces to look like, so you can report them, unfollow them, not give them the attention. Probably seen these three women before. They have been quite popular in the Luigi Mangione supporter realm. I don't get why the internet keeps giving disgusting ass people fucking platforms. We need to stop doing that. Stop giving horrible people platforms. Give good people platforms. Is that so hard to ask? You've probably seen the blonde one a couple of times. You've seen her in live streams. You've seen me talk about her once in the past, because what she did was leaked footage to the public when it wasn't meant to whatsoever. The fucking audacity for her to make me talk about her again. How fucking dare you? I'm more annoyed about that. Why are you making me talk about you? How dare you? But this is my platform, so I get to talk about whatever the fuck I want. So basically what these three women did, celebrating the murder of Brian Thompson, and that is absolutely fucking disgusting behavior, and also chanting and cheering for his murder. That is absolutely fucking disgusting behavior for anyone to do. You should not chant anyone's murder whatsoever. And the reason why this also got so big, not just because they fucking did that and they're popular and the media loves freaking giving them fucking attention, is because they were wearing press passes. Now, if you guys already know this or didn't know this, the press passes get way more priority in court cases, trials, etc., also hearings, etc., more so than the normal everyday people passes people can get. Those three women and wearing those passes that you could clearly see, and basically that's also why the fuck this got so big. Now, I don't truly know how they got those press passes. Maybe they just threw a lot of money and that's how they got into it. I feel like that is the option how they did, instead of, actually being part of the media. But honestly, Rotten Mango got into the media side of things in Luigi Mangione's case. I don't think it's that fun, but basically, that was also another reason why this got so big as well. Now, I am going to show you the statement Karen Agnifilo made about this situation. I'll pop it up on screen for you guys.
These individuals do not represent the views of Luigi, nor the tens of thousands who have shown their support from around the world. The only people who speak for Luigi are his attorneys. We condemn these vile and irresponsible statements that have no place in the discourse around these cases.
So that was the statement Karen made about this. This isn't from any official site or anything. This was from a newspaper. You know my beef about the media, but I feel like it was necessary to show this, and I absolutely agree with Karen Agnifilo. This was so big. Mamdani the next day made a statement about it, and I'll pop it up on screen for you guys so you can listen what he had to say about it. So basically, media passes can change in this situation, so this does not happen again. So I'll put it up on screen for you guys.
It's not. And those three individuals should not have received press passes. My administration is reviewing the entire process and the standards for press credentialing. The guidelines fall underneath the Mayor's Office of Media and Entertainment. We will initiate our own process to review these. And what I will say is there is a good-natured debate to be had about where a press pass should extend and where it shouldn't. However, the three people that we are talking about don't fall within that debate. I think one of the most important things is that I, as the mayor, should not be deciding who is considered a journalist worthy of a pass and who is not. However, what we should have is a process that people can trust. Because as you've said, the nature of news, how it is reported, how it is consumed has changed. The The city has to keep up with that. We have to ensure that if a New Yorker is getting their news in this manner, we also treat that legitimately. However, what we're talking about with regards to the 3 press passes that were reported on yesterday, that's not within that debate. What we need to do is put forward a process that is one where people can look at it and say, this is actually acknowledging the different ways in which to report. That's what we're reviewing right now, is how to put that together. At this point, it is still within the Mayor's Office of Media and Entertainment. That's where we're going to conduct that review to make sure we actually put together that process, and it's one that is actually reckoning with all of these different changing dynamics of the news environment. We're going to make sure that it's actually a much fairer one. Thank you.
That was the statement made by Mr. Mamdani about basically changing media passes in cases like this. But basically, I agree with these statements by Karen Agnifilo and also the other Luigi Mangione supporters online that I chat to time, that we've been talking about this, wanting to make a statement about this. These people do not speak on the behalf of Luigi Mangione. They do not speak on the behalf of other Luigi Mangione supporters that do not think this way whatsoever, and they do not speak on the behalf of Luigi Mangione's legal team, because the only people that talk on Luigi Mangione's behalf is his legal team. And I feel like it's incredibly important to talk about this, because this is absolutely fucking disgusting behavior, what these girls did. And the sad fact is, the media likes focusing and giving these women attention because they fucking love attention and they're pick-me women. They are acting like 15-year-old girls who have never basically had to deal with the consequences of their own fucking actions. This does not represent the Luigi Mangione community whatsoever, and this is my platform, and I feel like it's necessary to talk about this and bring this up because I do show my face, even if my page isn't that big compared to the other people I have been chatting about this in the Luigi Mangione supporter realm, and I feel like it is necessary to talk about this and make this statement here. It's fucking disgusting what they have done, and that should have never happened whatsoever. Disrespectful to everyone in this entire thing. Brian Thompson's family, Luigi Mangione, the Luigi Mangione supporters, and the only people that represent Luigi Mangione is his legal team. These women do not represent the Luigi Mangione community. They do not think this way whatsoever. They do not represent anyone around the world that's supporting Luigi Mangione. They do not think this way. They do not represent any of the Luigi Mangione supporters that are not like this whatsoever, and what they have done is absolutely fucking disgusting behavior, and they've never faced consequences in their fucking lives for their actions, and they need to stop acting like 15-year-old girls that are fucking pick-me women. And I don't want to call them supporters because they do not deserve that. Things need to change so people like this can't. Problem is, the media loves focusing and giving them attention. And they want attention, is what they want, and dusting. Something like this shouldn't have never happened. You guys do have a lot more power than you think, even if you don't show your face on camera like I do, or make little posts like some of the people I chat to time online about Luigi Mangione's case. You have a lot more power than you think. Like, if you guys see these women, see what they've done online, please report it. Please take it down, unfollow them, because sadly there are Luigi Mangione accounts online that share everything and anything in Luigi Mangione's case, even if it's not helpful, not true, not accurate information, and just spreading this information around. And I posted a video I recommend you guys to watch where someone said people are telling this guy's story but telling it incorrectly, and they reach out to those social media people, and the social media people don't answer or respond whatsoever. And the reason why I said if you do see this kind of stuff on, say, other Luigi Mangione social media platforms on like TikTok, Twitter, etc., and you see it, please report it, because even if those stupid report functions don't fucking work on social media, I know that for a fact, but if enough people do that, they do listen. So basically, if you do see it, please report it, unfollow them, don't give them the attention they need. Same thing with these direct women. If you see their stuff, unfollow them. You are not giving them the attention they need. If a bunch of people unfollow them, you're getting rid of the power they have of the attention they want. So, you have a lot more power than you guys think. So, if you see this kind of stuff, unfollow it, report it, or even block them. Even better. Doing that will give them less power because they're so popular in the Luigi Mangione supporter realm, and I feel like doing that will basically get rid of their popularity. I want to bring this up because when I was chatting to other Luigi Mangione supporters online about this, they have made statements about this. You guys can make a statement about this as well, because it is absolutely fucking disgusting behavior what these women have done. Oh my god, the heater finally turned on. It is fucking freezing in here. Anyway, and I decided to wear a cute top and skirt. Now, let's move on to the main part of the video that you guys are all here for. All the information and all the sources in this week's video will be up on the website on this week's episode, and if I miss anything or got anything wrong or anything like that, please let me know in the comments down below, or sure to pin it or bring it up in my next video. I am human, I am the only one working on all these videos, so I do make mistakes. And I do want to add this here, so there are photos in this document. I have tried my best to lighten them up the much as possible because they are in black and white and they're a bit hard to see. I did my best to lighten them up so you guys can actually see the photos. I do it in all my videos going over the documents and turn them into audio files so you guys can see the photos. Now, let's get into the video.
United States District Court, Southern District of New York, United States of America, against Luigi Nicholas Mangione, Defendant 25 CR 00176, MMG, Opinion and Order Margaret M. Garnet, United States District Judge. Defendant Luigi Nicholas Mangione has moved to suppress the search of a black backpack recovered from him at the time of his arrest on December 9, 2024, and all items contained therein. For the reasons that follow, the motion is denied. Background are relevant facts. The relevant facts are largely undisputed. On December 9, 2024, the defendant purchased food at a McDonald's restaurant in Altoona, Pennsylvania, and was seated at a table in a rear corner of the restaurant. An employee of the McDonald's called 911 to report that a customer, the defendant, resembled the person who had been featured in news reports, as the defendant also moved to suppress statements made to the police at the time of his arrest. DKT, number 59. Based on the government's subsequent representation that the only such statements they were seeking to admit at trial were the defendant's alleged identification of himself as Mark and Mark Rosario, the motion to suppress was withdrawn. CDKT, number 92. Oral Arg. TR, at 5:10:18. The parties agreed with the summary of undisputed facts provided by the court at January 9, 2026, oral argument. See Oral Arg. TR at 18:21-1923. The facts described herein reflect the court's previous recitation and the undisputed portions of the factual recitations contained in the parties' submissions. CDKT, number 59-1, Agnifilo F. DKT, number 59-2, Def. BR, at 30:34, DKT, number 71, Op. at 1993, as well as body-worn camera footage of defendant's arrest, CDKT, numbers 71-1, Op. X, GX 1 inches, 71-2, Op. X, GX 2 inches, 71-3, Op. X, GX 3, an Altoona Police Department incident report regarding defendant's arrest, CDKT, number 71-4, Op. X, GX 4 inches, and an accept of an affidavit of probable cause in support of a search warrant obtained by the District Attorney of Blair County, Pennsylvania, CDKT, number 71-7, Op. X 7 inches. Case 125 CR 00176 MMG Document 102, filed the 30th of January 2026, page 2 of 43. Possible killer of Brian Thompson, a health insurance executive who had been shot dead on a street in Midtown Manhattan on December 4, 2024, a massive law enforcement operation to identify and locate the gunman had followed Thompson's murder, including release of video and still photographs depicting the potential shooter to the media. 2 officers of the Altoona Police Department initially responded to the McDonald's and approached the defendant at the table where he was sitting. A black backpack, the backpack, was on the floor near the defendant, leaning against the wall. The officers asked the defendant if the backpack was his, and he said that it was. As the officers proceeded to ask the defendant a number of questions, such as his name and whether he had recently been in New York City, an officer moved the backpack to a nearby table, out of the defendant's immediate reach. When it became clear that the officers believed the defendant likely was the person being sought in connection with the Thompson murder and was going to be taken into custody, one of the Altoona police officers did a cursory search of the interior of the backpack for anything that could hurt or injure her during the transport to the police station. In the course of that initial search, the officer found a loaded gun magazine. The backpack was then transported to the police station in one car, while the defendant was placed under arrest and transported in another car. At the police station, the same officer conducted a more thorough search of the backpack, recovering, among other things, a handgun, a silencer, a red notebook with writing inside, additional written materials, an iPhone, and various electronic storage devices. The one defendant contends that this initial cursory search exceeded the bounds of a permissible safety search after the magazine was found. See Def. BR at 3031. Even if the court agreed that the examples cited by the defendant likely exceeded that scope, that potentially overzealous conduct does not bar the admission of the evidence because of the doctrine of inevitable discovery, discussed further below. 2. Again, defendant contends that this search exceeded the bounds of a legitimate inventory search under the Altoona Police Department's standard policies for such searches. CID at 3334. For the backpack and its contents were eventually transported back to Manhattan, where Brian Thompson was killed and where local and federal authorities were investigating the murder. On December 16, 2024, the United States Attorney's Office for the Southern District of New York applied for a search warrant to search the entirety of the backpack and its contents, including any written materials contained therein. The warrant application was based on a sworn affidavit submitted by FBI Special Agent Gary Cobb, and was approved by a magistrate judge in this district on December 31, 2025. The court issued an order asking the parties to submit a letter indicating whether either party believed an evidentiary hearing was necessary to aid in the court's evaluation of the government's inventory search and inevitable discovery arguments, or any other aspect of the defendant's motion to suppress the contents of the backpack. DKT, number 79. In response, the defendant argued, both in writing and at oral argument on January 9, 2026, that the written policies of the Altoona Police Department regarding searches incident to arrest or inventory searches did not clearly apply to detainee property other than that removed from the detainee's body or person. After hearing argument, the court ordered a hearing on the limited question of what were the policies and standardized practices of the Altoona Police Department in December 2024 regarding the securing, safeguarding, and inventorying of the personal property of a person arrested in a public place. DKT, number 90. The court held a suppression hearing on January 23, 2026. See transcript of January 23, 2026, hearing, HRGTR. The government called one witness, Deputy Chief Nathan Snyder. Reasons discussed below, even if that were the case, the aspects of the search that the defendant identifies as excessive or outside policy do not affect the inevitable discovery analysis. 5. The warrant application and accompanying affidavit is attached hereto as Exhibit A. It is undisputed that the backpack was not physically removed from the defendant's body by the police from the Altoona Police Department and introduced into evidence. 5 exhibits, comprising certain policies and procedures of the Altoona Police Department in effect as of December 2024, General Order 3.1, HR'(GX), GX1, General Order 3.6, HRGX, GX2, General Order 3.5, HRGX, GX3, a probationary officer training task sheet regarding custodial arrest procedures, HRGX, GX4, and a probationary officer training task sheet regarding detention of prisoners, HR'(GX). GX5. Deputy Chief Snyder did not participate in any way in the defendant's arrest on December 9, 2024 and has had no involvement in any investigation into the defendant, HR'(GTR) at 11/24/12/17. Rather, he was presented as a person of suitable authority and expertise regarding the written policies and regular practices of the Altoona Police Department in December 2024. CDKT, number 90. Defendant called no witnesses and introduced into evidence one exhibit, Altoona Police Department General Order 1.2, HRGX, DXA. Deputy Chief Snyder testified about his experience working as a field training officer, and later a supervisor of Altoona's field training program for new police officers, HR'(GTR) at 7/15/9/10. Throughout his highly credible testimony, he demonstrated a thorough knowledge of and facility with the written general orders of the Altoona Police Department, as well as the written materials used to train new police officers, and the standardized practices of the department regarding arrests in public places and the proper handling of a detainee's property, whether property with him or her at the time of arrest or property removed from his or her person while being processed at the police station. See generally ID, HR'(GEXS, GX1 GX5. In sum, the testimony and exhibits at the hearing established that it is the standardized and regular practice of the Altoona Police Department to secure and safeguard the personal property of a detainee arrested in a public place. Officers are trained to search bags or closed containers that could reasonably contain items dangerous to officers in a way consistent with identifying and securing any such items before the bag is transported in a police vehicle. HR'(GTR) at 57/14/58/19, HR'(GEXS, GX2 at 2, GX4 at 2/3. When the property and the detainee arrive at the police station, the detainee's person should be thoroughly searched, and all of the detainee's property, whether taken from his or her person or secured at the time of arrest, should be searched and logged to the degree necessary to prepare a thorough inventory. HR'(GTR) at 58/20/60/19, HRGEXS, GX1 at 6, GX5 at 1. The searching and inventorying serve a range of law enforcement purposes, including ensuring the physical safety of detainees and officers, ensuring that accurate records are kept of any property that the department is responsible for safeguarding, ensuring that any detainee property is returned to a released detainee or properly transferred with a detainee going to another facility, ensuring integrity of operations so that property cannot be stolen, and protecting the department and its officers against false allegations of theft or loss. HRGTR at 48/19/49/04, 60/20/61/18. Deputy Chief Snyder testified that if items that appear to be evidence of a crime are discovered during an inventory search, the best practice would be to stop the inventory search and secure a search warrant. Although Deputy Chief Snyder acknowledged that the timing of that step could depend on the totality of the circumstances and might not be done immediately or until after the inventory search was completed, ID, at 61/24/63/16, discussion in his motion to suppress the backpack. The defendant argues that the backpack search that occurred at the McDonald's was not a valid search incident to arrest because the bag was no longer accessible to the defendant at the time it was searched, and that the purported safety search before transport was either a ruse or exceeded the permissible bounds of a pre-transport safety search. See Def. BR at 26/31. The defendant also argues that the inventory search of the backpack done at the police station was not valid because the purported inventory search was in fact a ruse for an evidentiary search, exceeded the permissible scope of an inventory search by, for example, reading the contents of certain writings recovered from the backpack, and otherwise did not follow established procedures. CID, at 31/34. Finally, the defendant argues that the inevitable discovery exception should not apply because the exception would have to be based on a permissible inventory search and the officers of the Altoona Police Department did not conduct a proper inventory search. CID, the government, in turn, argues that the backpack and its contents are admissible under several exceptions to the warrant requirement, including search incident to arrest, pre-transport safety search, an inventory search at the police station, and, in the alternative, inevitable discovery arising from a combination of an inventory search and December 16 federal search warrant, which did not rely on any information gleaned outside of these permissible activities. See Op. 96-102. While the defendant likely has the better of the argument on search incident to arrest, the court need not belabor that point, because, as explained more fully below, the entire contents of the backpack fall squarely within several exceptions to the warrant requirement, most notably the inevitable discovery doctrine, through a combination of either a pre-transport safety search or an inventory search, followed by the federal search warrant, which plainly was supported by probable cause without reference to any information learned outside of the permissible bounds of either of these two precursor searches. Although neither party argued this point, the contents of the backpack would also likely be admissible under the good faith exception, based on the federal warrant. See United States v. Garnet, 824 F. 3D 199, 221, 2D 2016, T. The exclusion of evidence is inappropriate when the government acts in objectively reasonable reliance on a search warrant, even when the warrant is subsequently invalidated. Quoting United States v. Leon, 468 U.S. 897, 922, 1984. 1. Safety and inventory searches. The Fourth Amendment protects individuals from unreasonable searches and seizures and, absent an applicable exception, the law generally presumes that a judicially authorized warrant is required for a search to be reasonable. See, for example, Katz v. United States, 389 U.S. 347, 357, 1967. Outside of established and well-delineated exceptions, warrantless searches are per se unreasonable. Riley v. California, 573 U.S. 373, 38182, 2014. The ultimate touchstone of the Fourth Amendment is reasonableness, which generally requires the obtaining of a judicial warrant. Two such exceptions to the warrant requirement are searches necessary for officer or community safety, and searches done to inventory property taken into police custody. While a safety search is most commonly applied to a search of a detainee's person when he or she is taken into custody, courts have also recognized that the exception can apply when officers have reason to believe that a bag or other closed container that must be transported in a police vehicle may contain some immediately dangerous object, such as an incendiary device or noxious chemicals. In such circumstances, officers may conduct a warrantless search of the bag to the extent necessary to confirm the presence or absence of immediate danger. See United States v. Chadwick, 433 U.S. 1, 15N, 9, 1977, abrogated on other grounds by California v. Acevedo, 500 U.S. 565, 1991, United States v. Murillo, 2009 WL 3254431, at star 78, EDNY October 9, 2009. Police need not carry a dangerous backpack in their police car, without either aid unless otherwise indicated. Case quotations omit all internal citations, quotation marks, footnotes and omissions, and adopt alterations. As noted above, the parties' briefing devoted extensive attention to another established exception to the warrant requirement, a search incident to arrest. See Def. BR at 2631, Op. at 9697. The applicability of this exception presents the closest question under the facts of this case, but the court need not resolve it because the backpack and its contents are admissible under other applicable exceptions. Affirming or dispelling their reasonable suspicion. United States v. Matthews, 532 FAPP' 211, 223, 225-26, 3D 2013. Upholding search to ensure officer safety before transporting luggage defendant had in his possession at the time of his arrest in a public place. United States v. Hopewell, 498 FAPP' 609, 612, 7th 2012, holding that exigent circumstances justified the search of a backpack left on a bus after an arrest where officers reasonably believed that the search was necessary to prevent serious injury to themselves or to the public. United States v. Antonio, 386 FAPP apostrophe X 678, 680, 9th Sid 2010, upholding search of a backpack because property taken into police custody is routinely inventoried for any weapons before transport. Such a search was reasonable under the facts of this case. At the time of his arrest in the McDonald's, the defendant was suspected of being the person who had gunned down a stranger on a street in Midtown Manhattan, using a handgun equipped with a silencer, and leaving behind shell casings that had been inscribed with the words delay, deny, and depose, an apparent reference to the victim's work as the chief executive of a private health insurance company. Agnifilo F14. The circumstances clearly suggested at least the possibility of a political or ideological motive to send a public message, through the use of violence, about the health insurance industry, and little was otherwise known about the perpetrator, including whether he had acted alone or as part of a group, and whether the Thompson murder was an isolated incident or was part of a larger plot contemplating further violence. Police need not have certainty or even probable cause to take steps to protect themselves and the public, so long as their actions and the suspicions that prompt them are reasonable. Under these circumstances, police were justified in conducting a safety search of the backpack before it was transported. See Ross v. California, 2013 WL 2,898,066, at Star 10, CD Cal, June 10, 2013. Officers were on the lookout for someone matching plaintiff's description, and he evidenced that plaintiff was possibly involved with other criminal activity, especially involving a concealed weapon, made the search of his backpack reasonable for purposes of officer safety. Such a search would also be consistent with the established practices and training of the Altoona Police Department. CHRGTR at 580419. Here, the backpack was opened at the McDonald's before transport and a cursory search was conducted, as the officer can be heard on her body camera stating that she needed to be sure the bag did not contain a bomb or anything before she put it in her car. COP, EXS, GX2 at 10:01-10:03, GX3 at 10:16-10:17. While feeling around inside the bag for items that could be dangerous, the officer almost immediately pulled out a heavy metal item wrapped in an article of clothing, which turned out to be a loaded handgun magazine. COP-X, GX2 at 10:01, 1 degrees in sum. The loaded magazine is admissible as the product of a reasonable pre-transport safety search. Inventory searches meaning searches conducted of property in the custody of the police in order to identify and log anything the police are responsible for storing or safeguarding are another well-defined exception to the warrant requirement. Illinois v. Lafayette, 462 U.S. 640, 643, 648, 1983. It is not unreasonable for police, as part of the routine procedure incident to incarcerating an arrested person, to search any container or article in his possession, in accordance with established inventory procedures. Inventory searches do not violate the Fourth Amendment because their goals are unrelated to the warrant requirement or the necessity of probable cause. Rather, they serve to protect an owner's property while it is in the custody of 10. The defendant argues that the safety search at the McDonald's should be disregarded because, even if some limited search was justified, officers exceeded the bounds of a reasonable safety search after the magazine was found when they, for example, cut open a small cardboard sleeve to reveal a computer chip inside. See Rep. at 3940. The government does not rely on any of the arguably excessive aspects of this safety search in opposing suppression, and, in any event, whatever may have been done after the discovery of the magazine does not void the applicability of the inevitable discovery doctrine, discussed below. The police, to ensure against claims of lost, stolen, or vandalized property, and to guard the police from danger. United States v. Mendez, 315 F, 3D 132, 137, 2D C 2002. See also United States v. Williams, 930 F, 3D 44, 5354, 2D C 2019. To be valid, inventory searches must be conducted using standardized criteria or established routine. Florida v. Wells, 495 U.S. 1, 4, 1990. A police department's standardized procedures may be established by written rules and regulations or by testimony regarding the department's standard practices. See United States v. Thompson, 29 F, 3D 62, 6566, 2DC 1994, Williams, 930F, 3D at 54. Here, Deputy Chief Snitter's testimony and the exhibits offered at the suppression hearing amply established that the Altoona Police Department has written procedures and rules regarding the searching and inventorying of any property brought into the police station, and that officers are trained in these standard practices. CHR''GTR at 58-20-60-19, HRGEXS, GX1 at 6-7, GX5 at 1. When the officer who transported the backpack arrived at the station, she thoroughly searched the backpack with her body-worn camera running for approximately 12 minutes. She again identified the loaded magazine she had first found at the McDonald's, and then relatively quickly located a handgun and a silencer in the backpack, along with a variety of other items, COP, X, GX3 at 10-16-10-28, all of which were subsequently secured and logged, with evidentiary items separated from personal items and all items documented, COP, EXS, GX4, GX7. The government has established by a preponderance of the evidence that the search of the backpack at the Altoona Police Department was consistent with the written regulations and standard practices for an inventory search, even if not done perfectly, and thus the contents recovered are admissible. See United States v. Lopez, 547F, 3D 364, 369, 372, 2DC 2008, upholding District Court's conclusion that minor deviations from any required listing procedures would not invalidate an inventory search. United States v. Antonio Fabian, No. 16, Case 125 CR 00176 MMG Document 102, filed 30 January 2026, page 11 of 43 CR 00131, DLI. 2019 WL 3,578,226, at *7, EDNY August 6, 2019, holding that officers' alleged departure from inventory procedures, without more, does not render the search unconstitutional provided the search was conducted in good faith pursuant to standardized criteria or established routine. In response, the defendant originally argued that the government had failed to demonstrate that Altoona Police Department had an established procedure for inventory searches of bags seized in connection with an arrest, def. BR at 33, but those policies were amply established at the hearing. Next, the defendant noted that the Altoona policy for searches of impounded vehicles requires obtaining a warrant if evidence of a crime is discovered during an impounded vehicle inventory search. See General Order 1.2.3, C. 5, C, HR''GX, DX are at 8, and argued that a similar requirement should be imputed to all other inventory searches by analogy, see def. BR at 34. But the Altoona Police Department's written procedures for inventory searches of other property brought into the police station do not contain this provision. On reply, the defendant further argued that the inventory search was invalid because the officer's real motive and conduct suggested that she was searching for evidence rather than conducting a true inventory search. CDKT, number 76, Rep. at 4142. This argument is squarely foreclosed by Williams, 930F, 3D at 5556. In general, an action is reasonable under the Fourth Amendment, regardless of the individual officer's state of mind, as long as the circumstances, viewed objectively, justify the action, and by Lopez, 547F, 3D at 372, when officers, following standardized inventory procedures, seize, impound, and search a car in circumstances that suggest a probability of discovering criminal evidence. The officers will inevitably be motivated in part by criminal investigative objectives. Such motivation, however, cannot reasonably disqualify an inventory search that is performed under standardized procedures for legitimate custodial purposes. Finally, the defendant suggested through cross of Deputy Chief Snyder at the hearing that Altoona's standard procedures required a search warrant be obtained and no further searching be conducted if evidence of a crime was discovered during any kind of inventory search. But Deputy Chief Snyder did not so testify, and the written policies of the Altoona Police Department do not support this argument. Deputy Chief Snyder was very clear that any and all property being held by the Altoona Police Department, for any reason, must be fully inventoried and logged. CHR apostrophe GTR at 150620, 1619 1816, 1920 23, 22 13 24, 3709 3809. He also testified that, under certain circumstances, he viewed it as best practice, and would so train new officers to seek a search warrant for a bag once items that could be evidence in a criminal investigation were found, but that the timing of that could vary considerably depending on the circumstances. CID, at 6124 63 16, at no point did he suggest that the remaining contents of the bag would not have to be inventoried and logged, or that immediately seeking a search warrant was per se required by the department's written policies or standard procedures. The search of the backpack at the Altoona Police Department falls within the inventory search exception, and therefore its contents are admissible on this basis as well. 11. In discussion of whether an evidentiary hearing was needed, the defendant also argued that the officer exceeded the scope of a valid inventory search, after the magazine, firearm, and silencer were found in the course of that search, by reading certain passages from a red journal found in the backpack and the content of other writings. CDKT, number 81 at 3. This argument was not raised in the defendant's motion to suppress. First, as with the argument above at N10, as a general rule, the fact that an officer may have, in some respects, exceeded the scope of an otherwise permissible search would not require the suppression of evidence lawfully obtained during the permissible scope of that search. See, for example, United States v. Rudaj, 390 F sub 2D 395, 400-02, 406 N, 3, SDNY 2005, police seized a number of items under a plain view theory, which is a permissible exception to the warrant requirement. Fact that court suppressed some items because police exceeded the bounds of plain view when they seized them did not require suppression of other seized items that did fall within the exception. United States v. Irango, Korea, 851 F, 2D 54, 59, 2D C 1988, holding that defendants' contention that agents exceeded the permissible scope of the inventory search when they opened two notebooks, which defendant likens to closed containers, cannot stand in light of Supreme Court precedent, and, second, the contents of the 2. Inevitable discovery. Finally, however, even if the defendant were correct that it was not reasonable for officers to conduct a pre-transport safety search of the backpack, and thus that the loaded magazine would not have been discovered at the McDonald's, or that under the established inventory search procedures of the Altoona Police Department, any search should have stopped in favor of a warrant as soon as one or more of the loaded magazine, firearm, or silencer were discovered, the contents of the backpack are still admissible in light of December 15 federal search warrant under the inevitable discovery doctrine. The exclusionary rule is a court-made doctrine that generally requires evidence obtained in violation of the Fourth Amendment's warrant requirement or a recognized exception to that requirement be suppressed and not offered as evidence at trial. See, for example, Davis v. United States, 564 U.S. 229, 236-37, 2011. It is a prudential doctrine that is remedial and intended to compel respect for the constitutional guarantee. ID, at 236. The doctrine of inevitable discovery is an exception to the exclusionary rule first recognized by the Supreme Court in Nix v. Williams, 467 U.S. 431, 1984, which identified the exception as closely related and functional, similar to the independent source doctrine in other exception to the exclusionary rule, ID, at 443-44. The independent source doctrine allows admission of evidence that has been discovered by means wholly independent of any constitutional violation because exclusion of such evidence would not serve the exclusionary rule's deterrent purpose, ID, at 443. Instead, exclusion would put the prosecution in a worse position simply because of some earlier police error or misconduct, thereby upsetting the balance between the interest of society and written materials found in the backpack are plainly within the scope of the federal search warrant, discussed below, deterring unlawful police conduct and the public interest in having juries receive all probative evidence of a crime, ID. In Nix, the Supreme Court applied the same reasoning to endorse the inevitable discovery doctrine as an extension of the independent source doctrine. If the prosecution can establish by a preponderance of the evidence that the information ultimately or inevitably would have been discovered by lawful means, then the deterrence rationale has so little basis that the evidence should be received. Anything less would reject logic, experience, and common sense. ID, at 444. The inevitable discovery doctrine allows the fruits of an illegal search or seizure to be nevertheless admitted at trial if the government can prove that the evidence would have been obtained inevitably without the constitutional violation. United States v. Heath, 455 F. 3D 52, 55, 2D C 2006. The government bears the burden of proving inevitable discovery by a preponderance of the evidence. Nix, 467 U.S. at 444, United States v. Cabasa, 62 F. 3D 470, 472-73, 2D C 1995. Proof of inevitable discovery involves no speculative elements but focuses on demonstrated historical facts capable of ready verification or impeachment. United States v. N. 971 F. 2D 854, 859, 2D C 1992, quoting Nix, 467 U.S. at 444 N. 5. Emphasis in N. The focus on demonstrated historical facts avoids undue speculation by requiring the district court to determine, viewing affairs as they existed at the instant before the unlawful search, what would have happened had the unlawful search never occurred. ID, at 861, emphasis in original. Evidence should not be admitted, therefore, unless a court can find, with a high level of confidence, that each of the contingencies necessary to the legal discovery of the contested evidence would be resolved in the government's favor. Heath, 455 F. 3D at 60, see also ID. Under the inevitable discovery exception, unlawfully seized evidence is admissible if there is no doubt that the police would have lawfully discovered the evidence later, quoting United States v. Romero, 692 F. 2D 699, 704, 10th C 1982, emphasis in Heath. In this case, the first violation the defendant alleges is that the pre-transport safety search, in which the loaded magazine was recovered, was not justified. However, the record clearly establishes that the backpack was taken from the McDonald's by the Altoona Police Department as part of their standard safeguarding procedures for the personal property of a person arrested in a public place, and there is no doubt that the backpack would have been transported to the police station even if the pre-transport safety search had not occurred or the initial cursory search had failed to turn up the loaded magazine. See, for example, HRGTR at 25-23-27-4. Once at the station, the record also clearly establishes that the standardized procedures of the Altoona Police Department would have required that the backpack be opened and its entire contents inventoried and logged. The Mendez factors govern when inventory search procedures can establish the grounds for inevitable discovery. 1. That the police had legitimate custody of the property being searched, so that an inventory search would have been justified. 2. That when the police and the police agency in question conducted inventory searches, they did so pursuant to established or standardized procedures. And 3. That those inventory procedures would have inevitably led to the discovery of the challenged evidence. United States v. Mendez, 315 F. 3D 132, 138. 2D C 2002.2. Even if the defendant is correct that the standardized procedures of the Altoona Police Department would have required that any inventory search stop in favor of a search warrant once the loaded magazine, the handgun, and/or 12. The defendant's arguments regarding the Mendez factors conflate the inventory search exception and the inevitable discovery exception by arguing that the factors cannot be met because the inventory search actually conducted was not proper. But, even assuming the defendant were correct, that is not the test. In any inevitable discovery analysis, the premise is that some unlawful search has been conducted, and the court is assessing whether the exclusionary rule need not be applied because the evidence would have been inevitably discovered through some predictable and near certain lawful means. The silencer were found in the backpack in the course of that inventory search. A search warrant was in fact obtained, first by local authorities and then, more importantly for our purposes, by the federal authorities prosecuting the instant case. The federal search warrant for the contents of the backpack, authorized by a magistrate judge in this district on December 16, 2024, is based almost entirely on evidence gathered independent of searches conducted by the Altoona Police Department that the defendant now claims were unlawful for, even accepting defendant's premise that any inventory search should have ceased in favor of a warrant once the firearm, recovered first in the search at the police station, had been found, and removing from paragraph 10 of the search warrant the reference to the silencer, the U.S. passport and currency also found in the backpack, and references in paragraphs 11, 12, and 13 to the exterior of written materials seen in the backpack. The warrant affidavit still contains overwhelming probable cause to search the entire contents of the backpack in service of the federal investigation into Brian Thompson's murder. Taking all of these facts together, the court has little difficulty concluding that, whether characterized as inevitable discovery or independent source, the contents of the backpack are not subject to the 13, even assuming the defendant is correct that any inventory search should have ceased once evidence of a crime was found. Given Pennsylvania's gun laws, it is not clear that point would be reached merely by finding a loaded magazine or a handgun, as opposed to the silencer, which is clearly unlawful and, in the sequence of the inventory search actually conducted, was the third of these items found. However, the defendant did not explore this issue with Deputy Chief Snyder, and the record is not well developed on this question 14 here. December 14 federal search warrant could also support denial of the suppression motion under the independent source doctrine, since the warrant plainly supported probable cause even without any reference to items that the defendant argues exceeded the bounds of permissible earlier searches, and the decision to seek the warrant was not prompted by information gleaned from any improper police conduct. See, for example, United States v. Mulholland, 702 FAPP'(X7, 1011, 2DC 2017, applying independent source doctrine to warrant obtained over a year after initial search of laptop, which was done on mistaken belief that proper consent had been given. However, the government did not expressly argue independent source as a basis, and for the reasons stated herein, the court need not rely on this exception as denial of the motion is amply supported on other bases. Exclusionary rule under applicable precedents and the evidence contained therein should not be suppressed. This case is strikingly similar to United States v. Villa, 729 F. 3D62, 2DC 2013, in which the Second Circuit upheld an inevitable discovery ruling where evidence obtained through a warrant later found to be invalid due to overbreadth was subsequently obtained through a grand jury subpoena. Similar to this case, no great feat of imagination or resolving fuzzy contingencies in favor of the government was required, because the court could be confident that the sequence is what would have happened, because it did happen. This case presents the unusual scenario where the actual events played out exactly as they would have but for the overbreadth of the warrant, because the government actually obtained the evidence through alternative means that did not depend on any invalidity of the warrant. The record, therefore, confirms that the government would have validly discovered the documents produced pursuant to the subpoena, but for the overbreadth of the warrant. Villa, 729 F. 3D at 8485, and going on to reject the defendant's argument that ENG does not allow for using legal process to cure faulty prior police action. Conclusion: in sum, numerous exceptions to the warrant requirement, as well as the federal search warrant actually issued, preclude suppression of the backpack and its contents in this case, whether through the discovery of the loaded magazine during a pre-transport safety search, the recovery of the remaining items in the course of an inventory search at the police station, or the inevitable discovery of all of the contents through the federal search warrant, even excising references to any items found or seen after the magazine, firearm, and/or silencer were found. Accordingly, the motion to suppress the backpack and its contents is denied. Dated January 30, 2026, New York. New York, so ordered. Margaret M.I. Garnet, United States District Judge. Exhibit A. United States District Court for the SWAT in Abyssy at Now Y. 1 Mac 24 Mag 846 pounds. In the matter of the search of briefly describe the property to be CKR, identify the person by name and address, black backpack identified in attachment to hereto, and any written materials contained therein. Case No. Application for a search and seizure warrant I. a federal law enforcement officer or an attorney for the government, request a search warrant and state under penalty of perjury that I have reason to believe that on the following person or property, identify the person or describe the property to be searched and give its location, black backpack identified in attachment hereto, and any written materials contained therein located in the Southern District of New York. There is now concealed, identify the person or describe the property to be seized. See attached affidavit and its attachment to the basis for the search under Fed. Acrim. P41. C. Is. Check one or more. X evidence of a crime. X contraband, fruits of crime, or other items illegally possessed. X property designed for use, intended for use, or used in committing a crime. A person to be arrested or a person who is unlawfully restrained. The search is related to a violation of Code Section S. Offense description S. 18 U.S.C. 924, 0, murder through use of a firearm, aiding and abetting 18 U.S.C. Section 924, c, firearms possession and discharge 18 U.S.C. 2261a interstate, stalking and stalking by use of interstate facilities. The application is based on these facts. See attached affidavit and its attachment A continued on the attached sheet delayed notice of 30 days. Give exact ending date if more than 30 days, under 18 U.S.C. Section 3103a, the basis of which is set forth on the attached sheet, is requested sworn to before me and signed in my presence. Date, the 16th of December 2024. City and State, New York, NY. Applicant's signature Special Agent Gary Cobb. Printed name and title Cat and T. Paul. Judge's signature Honorable Catherine H. Parker. Printed name and title United States District Court, Southern District of New York. In the matter of the application of the United States of America for a search warrant for the black backpack seized from Luigi Nicholas Mangione on or about December 9, 2024, identified in attachment hereto, and any written materials contained therein to be filed under seal. Agent affidavit in support of application for search and seizure warrant, Southern District of New York. SS. Gary Cobb, being duly sworn, deposes and says, I introduction A. Affiant 1. I am a special agent with the Federal Bureau of Investigation, FBI or investigating agency. I have been a special agent with the FBI for approximately 5 years. I have participated in numerous investigations of shootings, murders, and other violent crimes and have become familiar with the ways that perpetrators of these crimes use of firearms and the methods they employ to plan, execute, and conceal their crimes. In the course of those investigations, I have conducted or participated in surveillance operations, undercover operations, debriefings of informants, and reviews of taped conversations and cellular phone data. Through my training and experience, I have also become familiar with the manner in which individuals who commit violent and other crimes prepare for their criminal activities, including using handwritten notes and letters, along with other measures these individuals employ to avoid detection by law enforcement. I have participated in the execution of search warrants, including search warrants for physical evidence such as that described below. 2. I make this affidavit in support of an application pursuant to Rule 41 of the Federal Rules of Criminal Procedure for a warrant to search the items specified below, the subject, backpack, and review any written materials contained therein for the items and information described in Attachment A. This affidavit is based upon my personal knowledge, my review of documents and other evidence, and my conversations with other law enforcement personnel, and my training, experience and advice received concerning the commission of violent and firearms-related offenses. Because this affidavit is being submitted for the limited purpose of establishing probable cause, it does not include all the facts that I have learned during the course of my investigation. Where the contents of documents and the actions, statements, and conversations of others are reported herein, they are reported in substance and in part, except where otherwise indicated. B. The subject backpack 3. As depicted below, the subject backpack is a black backpack that was seized incident to the arrest of Luigi Nicholas Mangione on or about December 9, 2024. As discussed further below, I believe the subject backpack contains evidence, fruits, and instrumentalities of Mangone's participation in the murder of Brian Thompson, the victim on December 4, 2024 in New York, New York. 4. See the subject offenses. The subject backpack is presently located in the Southern District of New York. For the reasons detailed below, I believe that there is probable cause to believe that the subject backpack contains evidence, fruits, and instrumentalities of violations of Title 18, United States Code, Sections 2261A, 1, Interstate Stalking, 2261A, 2, Stalking by use of interstate facilities, 924I, Murder through use of a firearm, and 924C, Firearms possession in relation to a crime of violence, the subject offences, ill. Probable cause. A probable cause regarding the commission of the subject offences based on my participation in this investigation, my conversations with other law enforcement officers, my review of documents prepared by others, and my review of security camera video. I have learned, among other things, the following. A. On December 4, 2024, at approximately 6:45 a.m., Brian Thompson, the victim, the chief executive officer of a nationwide health insurance company, Company 1, was shot and killed by a masked assailant, the shooter, while walking on East 54th Street toward a hotel in Midtown Manhattan, the Midtown Hotel, where a Company 1 investor meeting was scheduled to commence later that morning. Security camera video captured the shooter, who was wearing a gray backpack, and hiding between two parked cars, walk up behind the victim and shoot the victim several times in the leg and back outside of the Midtown Hotel's entrance on East 54th Street. The firearm the gunman used appeared to have a sound-suppressing device or silencer attached to the front of its barrel. A still image of the surveillance video from the shooting is provided below. The responding law enforcement personnel recovered, among other items, several spent 9mm shell casings and at least one live 9mm round of ammunition. The words deny, delay, and depose were written on the side of some of the casings using black marker. Based on my training, experience, and review of publicly available information, I know that the words deny and delay are words commonly associated with the health insurance industry, and a prominent book about the health insurance industry was published in or about 2010 titled Delay, Deny, Defend, Why Insurance Companies Don't Pay Claims and What You Can Do About It. Responding law enforcement personnel also recovered a cell phone in the vicinity of the location where the shooting had occurred, the shooter's cell phone. The investigation. Based on my participation in this investigation, my conversations with other law enforcement officers, my review of documents prepared by others, and my review of security camera video, I know that over the course of the next several days, investigators retrieved hundreds of hours of security camera video from nearby establishments and residences in an effort to capture the shooter's movements both before and after the murder. Through a review of the security camera video, investigators were able to formulate the following timeline of the shooter's movements from November 24, 2024 up to and including December 4, 2024, November 24, 2024 at approximately 10:11 p.m. The shooter arrived in New York City on a Greyhound bus at the Port Authority bus terminal in Manhattan. The bus originated in Atlanta, Georgia. The shooter took a taxi to the area around the Midtown Hotel and stayed in the area for approximately 1 hour before taking another taxi to a hostel located in the Upper West Side of Manhattan. The Upper West Side Hostel. The shooter registered at the Upper West Side Hostel under the name Mark Rosario and used a false New Jersey driver's license as a form of identification. The false New Jersey ID. While checking in at the Upper West Side Hostel, the desk clerk asked the shooter to remove his mask, which he did, revealing his face to a security camera, as shown below. NE stoppers 180D 5,788,277,122 P3D. Other than this interaction with the desk clerk, the shooter consistently kept his mask on throughout his time in New York, including while at the Upper West Side Hostel. December 4, 2024 at approximately 5:35 a.m., the shooter left the Upper West Side Hostel wearing a gray backpack and used an electric bicycle to travel down Central Park West to the area of the Midtown Hotel. At approximately 5:41 a.m., the shooter walked around the area of the Midtown Hotel and at one point purchased items from a nearby coffee shop. The shooter then returned to a bench in the vicinity of the Midtown Hotel. On at least one occasion, prior to the murder, the shooter was depicted using the shooter's cell phone at approximately 6:45 a.m. After waiting in the vicinity of the Midtown Hotel for approximately an hour, the shooter approached the victim, shot the victim multiple times, and then fled on foot to East 55th Street, where the shooter got on the electric bicycle and rode towards Central Park. After disappearing inside the park for a period of time, the shooter was picked up on video again exiting the park and riding north on Central Park West. However, after coming out of the park, the shooter was no longer carrying the grey backpack. Surveillance video stills of the shooter riding the electric bicycle towards Central Park while wearing the grey backpack, and then departing Central Park without the grey backpack appear below.
Hi, it's voiceover me. So if you guys aren't watching the screen and just listening to the audio version of this video, so basically page 28 of this document is basically just two pictures of, I'm assuming, CCTV camera footage. It is incredibly grainy and in black and white. So the first picture, I have no goddamn idea what it is. I've lightened up the best I can, but I still can't work out what it is. And then the second picture is also another picture of Central Park, where the backpack that was dumped in that park in New York. So that's just what this page is on page 28. Sorry, my description of it is terrible because I generally can't tell what it is.
At approximately 6:58 a.m., the shooter passed another camera in the Upper West Side of Manhattan on West 85th Street and Columbus Avenue riding the electric bicycle. 2 minutes later, at approximately 7 a.m., the shooter was filmed walking on foot on West 86th Street and Columbus Avenue without the electric bicycle. At approximately 7:04 a.m., the shooter got into a taxi that drove him to the George Washington Bridge bus terminal in the vicinity of West 107 to 9th Street and Fort Washington Avenue in Upper Manhattan. The shooter's face was captured in the back seat of the taxi K. At approximately 7:30 a.m., video footage from the George Washington Bridge bus terminal captured the shooter entering the facility. The shooter was then not seen exiting the bus terminal, suggesting that the shooter left New York City. On or about December 6, 2024, law enforcement officers searching Central Park found a grey backpack matching the appearance of the grey backpack worn by the shooter, as depicted below. The arrest and identification of the shooter. 8. Based on my participation in this investigation, my conversations with other law enforcement officers, my review of documents prepared by others, and my review of security camera video, I know the following. Among other things, on December 9, 2024, at approximately 9:14 a.m., a worker at a fast food restaurant in Altoona, Pennsylvania called the police about a male customer later identified as Luigi Nicholas Mangione, the defendant, who the worker believed bore similar features to the photos of the shooter that had been broadcast in the media in the days following the victim's murder. At the time, Mangione was carrying the subject backpack. Members of the Altoona Police Department responded and conducted a field investigation. The responding officers also found that Mangione matched the appearance of the shooter. When approached by the officers and asked for identification, Mangione offered the false New Jersey ID used by the shooter to check into the Upper West Side hostel. Mangione was then placed under arrest by the responding officers. Probable cause justifying search of the subject backpack and the written materials contained therein. Based on my participation in this investigation, my conversations with other law enforcement officers, my review of documents prepared by others, and my review of security camera video, and my training and experience, I know that the Altoona Police Department officers who arrested Mangione also conducted a search incident to arrest and an inventory search of Mangone's personal property, including the subject backpack, which Mangione possessed at the time of his arrest. 10. Inside the subject backpack, law enforcement officers recovered, among other things, 1. A loaded 9mm pistol and silencer consistent with the weapon used to kill the victim, and 2. A U.S. passport and approximately $10,000 in cash, approximately $2,000 of which was in a foreign currency. Photographs of the firearm and firearm suppressor recovered from the subject backpack are depicted below. 11. Law enforcement officers searching the subject backpack also observed, among other things, a note with the words "to the feds" written on the top, the feds letter, a note that appeared to be addressed to Mangone's family, the family letter, and a notebook, the Mangione notebook, with several handwritten pages contained therein that appeared to be written in the same handwriting as the feds letter. 12. As described above, the shooter appeared to intentionally leave behind shell casings and live ammunition with the words "deny," "delay," and "depose" at the scene of the murder of the victim. See Supra 16. As a result, I believe that the Fed's letter, the family letter, the Mangione notebook, and other handwritten materials in the subject backpack will also serve as handwriting exemplars that further confirm that Mangione was the shooter. 13. Based on my review of reports published in various media outlets, I know that Mangione was a member of Goodreads, which is an online platform that allows authors and readers to find and discuss books they have read. In early 2024, Mangione posted a favorable review of Ted Kaczynski's aka the Unabomber manifesto as the work of a political revolutionary. Mangone's review went on to promote the use of violence when all other forms of communication fail, concluding that the quote "violence never solved anything" is a statement uttered by cowards and predators. These comments establish that, prior to murdering the victim, Mangione read and wrote about the use of violence to achieve political and social goals. Moreover, Mangone's possession of letters to the Feds and to his family, along with a notebook, demonstrates that Mangione was writing in the days and months prior to the law enforcement officers photographed the Fed's letter, the family letter, and pages of the Mangione notebook. Other law enforcement personnel and I have reviewed those photographs. However, I am not relying on the contents of these documents as probable cause for purposes of this search warrant affidavit. Murder, when it is highly probable that he would have discussed what he planned to do, or had done, and whether there were additional acts that were being contemplated, and because Mangione has a proven interest in the writings of at least one known terrorist, I submit there is probable cause to believe that the subject backpack and any notes found therein will contain evidence of Mangone's mental state before, during, and after the subject offenses. Based on these comments, I believe that the subject backpack and the written notes found therein will contain evidence of the motivation behind the subject offenses. 14. On December 10, 2024, the day after Mangione was arrested, he was brought to a Pennsylvania courthouse for his first court appearance. As Mangione was being led into the courthouse, he turned to the media assembled outside of the courthouse and yelled, "It's completely out of touch and an insult to the intelligence of the American people." This comment is another example of Mangone's state of mind and an effort to influence the public about his stated goals. This is further proof that the written materials in the subject backpack are likely to contain evidence of Mangone's plans to murder the victim and possibly commit other acts of violence in furtherance of his agenda. 15. Based on the significant premeditation and planning that went into the commission of the subject offenses, including Mangone's interstate travel, planned movements within New York City, the surveillance and tracking of the victim, the elaborate efforts to avoid identification and apprehension, and the public comments made by Mangione on public forums, I believe that the subject backpack will contain the following items, all of which were either used in the commission of the murder. For example, a gun and ammunition would be carried and used to plan and carry out the stalking and killing of the victim. For example, electronic devices and company conspirator information, and would assist in the flight from New York and efforts to hide following the murder. For example, financial and travel information, firearms, ammunition, electronic devices, including cell phones, laptops, tablets, and photographic equipment, clothing worn during the commission of the subject offenses, or written materials regarding the preparation, planning and execution of the subject offenses, and any photocopies of those materials, bank records, checks, credit card bills, account information, and other financial records relating to the subject offenses, and any photocopies of those materials, calendar or other scheduling information relating to the subject offenses, including but not limited to travel itineraries and meetings with co-conspirators, evidence concerning the identity or location of co-conspirators involved the subject offenses and/or individuals involved in purchasing, selling, transporting, or storing firearms or ammunition, diary and notebook entries pertaining to the subject offenses, and any photocopies of those materials, handwriting exemplars, and any photocopies of those materials. Any documents pertaining to the travel and stay in New York City from November 24, 2024 up to and including December 4, 2024, and any photocopies of those materials. 16. Based on my training and experience, I know that individuals who engage in highly premeditated acts of violence designed to get public attention, like the murder of Company L's CEO outside of an investor meeting in New York City, frequently maintain and keep logs and notes of their plans for these acts of violence, their motivations for committing these acts of violence, and their plans for how to evade law enforcement detection. These logs and notes can contain, among other things, To-do lists for tasks to complete in advance of the act of violence, lists of schedules for how to commit the act of violence, and potential escape plans and routes from the scene of the crime. 17. Based on the foregoing, I respectfully submit there is probable cause to believe that evidence of the subject offences, including evidence that Mangione committed the subject offences, is likely to be found in the subject backpack, including enclosed containers and handwritten materials contained within the subject backpack. 2. Conclusion and ancillary provisions. 18. For all of the foregoing reasons, I respectfully request the court to issue a warrant to seize the items and information specified in Attachment A to this affidavit and to the search and seizure warrant. 19. In light of the confidential nature of the continuing investigation, I respectfully request that this affidavit and all papers submitted herewith be maintained under seal until the court orders otherwise. Gary Cobb, Special Agent, FBI, sworn to before me this 16th day of December, 2024. Cathet Fal. Honorable Catherine H. Parker, United States Magistrate Judge. Attachment AI. Items to search and seizure. The items that are the subject of this search and seizure warrant, the subject backpack, are described as follows. A. The black nylon backpack, pictured below, seized by the Altona Police Department on December 9, 2024, incident to the arrest of Luigi Nicholas Mangione and any containers or written materials contained therein. Attachment B. Items to be seized. A. Evidence, fruits, and instrumentalities of the subject offences. The items to be seized from the subject backpack consist of the following: evidence, fruits, and instrumentalities of violations of 18 U.S.C. 2261A. 1. Interstate stalking, 2261A. 2. Stalking by use of interstate facilities, 924. J. Murder through use of a firearm, and 924. C. Firearms possession in relation to a crime of violence. The subject offences: firearms, ammunition, electronic devices, including cell phones, laptops, tablets, and photographic equipment, clothing worn during the commission of the subject offences. 5. All written materials regarding the preparation, planning and execution of the subject offences, and any photocopies of those materials. 6. Bank records, checks, credit card bills, account information, and other financial records relating to the subject offences, and any photocopies of those materials, calendar or other scheduling information relating to the subject offences, including but not limited to travel itineraries and meetings with co-conspirators, evidence concerning the identity or location of co-conspirators involved, the subject offences and/or individuals involved in purchasing, selling, transporting, or storing firearms or ammunition. 9. Diary and notebook entries pertaining to the subject offences, and any photocopies of those materials. 10. Handwriting exemplars, and any photocopies of those materials. 11. Any documents pertaining to the travel to and from and his and stay in New York City from November 24, 2024 up to and including December 9, 2024, and any photocopies of those materials. United States District Court for the Southern District of New York in the matter of the search of, briefly describe the property to be searched or identify the person by name and address. Black backpack identified in attachment hereto and any written materials contained therein. 24 Mag case number 312 pound search and seizure warrant. 2. Any authorized law enforcement officer, an application by a federal law enforcement officer or an attorney for the government requests the search of the following person or property located in the Southern District of New York. Identify the person or describe the property to be searched and give its location. Black backpack identified in attachment hereto and any written materials contained therein. The person or property to be searched, described above, is believed to conceal. Identify the person or describe the property to be seized. Black backpack identified in attachment hereto and any written materials contained therein. The search and seizure are related to violation S of insert statutory citations. 18 U.S.C. 2261A. 1. Interstate stalking. 2261A. 2. Stalking by use of interstate facilities. 924. I. Murder through use of a firearm. 924. C. Firearms possession and use. I find that the affidavits, or any recorded testimony, establish probable cause to search and seize the person or property. You are commanded to execute this warrant on or before December 30, 2024, not to exceed 14 days, in the daytime 6 a.m. to 10 p.m. and at any time in the day or night as I find reasonable cause has been established. Unless delayed notice is authorized below, you must give a copy of the warrant and a receipt for the property taken to the person from whom, or from whose premises, the property was taken, or leave the copy and receipt at the place where the property was taken. The officer executing this warrant, or an officer present during the execution of the warrant, must prepare an inventory as required by law and promptly return this warrant and inventory to the clerk of the court. Upon its return, this warrant and inventory should be filed under seal by the clerk of the court. K1 I find that immediate notification may have an adverse result listed in 18 U.S.C. Section 2705, except for delay of trial, and authorize the officer executing this warrant to delay notice to the person who, or whose property, will be searched or seized. Check the appropriate box, off or days, not to exceed 30. Cuntal, the facts justifying, the later specific date and time issued, Catherine City and State, the 16th of December 2024 5:44 p.m. New York. NY Judge's signature Honorable Catherine H. Parker, printed name and title AO93, SDNY Reverend 01/17, search and seizure warrant, page 2, return date and time warrant executed, case no, inventory made in the presence of, inventory of the property taken and name of any person, S, seized, copy of warrant and inventory left with, certification I declare under penalty of perjury that this inventory is correct and was returned along with the original warrant to the court. Date, executing officer's signature, printed name and title. Attachment AI items to search and seizure are described as follows. The items that are the subject of this search and seizure warrant, the subject backpack, A. The black nylon backpack, pictured below, seized by the Altona Police Department on December 9, 2024 incident to the arrest of Luigi Nicholas Mangione and any containers or written materials contained therein. Attachment BI items to be seized. A. Evidence, fruits, and instrumentalities of the subject offences. The items to be seized from the subject backpack consist of the following evidence, fruits, and instrumentalities of violations of 18 U.S.C. 2261A, 1. Interstate stalking, 2261A, 2. Stalking by use of interstate facilities, 924, I. Murder through use of a firearm, and 924, C. Firearms possession in relation to a crime of violence. The subject offences, firearms, 2. Ammunition, electronic devices, including cell phones, laptops, tablets, and photographic equipment, 1. Clothing worn during the commission of the subject offences, 2. All written materials regarding the preparation, planning and execution of the subject offences, and any photocopies of those materials. 6. Bank records, checks, credit card bills, account information, and other financial records relating to the subject offences, and any photocopies of those materials, calendar or other scheduling information relating to the subject offences, including but not limited to travel itineraries and meetings with co-conspirators, evidence concerning the identity or location of co-conspirators involved the subject offences and/or individuals involved in purchasing, selling, transporting, or storing firearms or ammunition, diary and notebook entries pertaining to the subject offences, and any photocopies of those materials. 10. Handwriting exemplars, and any photocopies of those materials. 11. Any documents pertaining to the travel to and from and his and stay in New York City from November 24, 2024 up to and including December 9, 2024, and any photocopies of those materials.
Okay, so that was the end of the documents submitted by Judge Garnett denying Karen Agnifil's motion to suppress everything in Luigi Mangione's backpack, and also some of his statements as well that came out on the 30th of January 2026. Okay, back to my regular outro I filmed like 2 days ago when I thought I did not make a massive mistake. And like I said earlier in the video, I will start doubling up. I have like 2 more documents I need to turn into audio files, so next week I'll just double up or write release 2 videos next week compared to, once a week like I've been doing. I'm getting tired of not yapping about things. I miss not talking about things that are important. And I will do a little breakdown and all that in the future of all these audio documents I've done in the past. It'll be very similar to like my Karen Agnifilo videos that I made earlier last year, where I made an audio version of the document and then I broke down the document. That will come out in the future and all that again. Thank you for watching this week's video. You can subscribe if you want to. It's okay if not. I upload 3 times a month, and if you guys want to keep up to date with the channel, you can follow the channel's social medias. That'll be in the description down below. And if you guys want to follow me personally, all of my social medias are down below in the description down below. And yeah, thank you for watching. Bye.